Hello, Dr. Suzanne Bechtel, lecturing today on the overview and processes of alternative dispute resolution, also called ADR. This lecture is going to provide a fairly medium depth look at alternative dispute resolution, focusing on the nature of conflicts and disputes and the key processes used in arbitration and mediation, and how and their effectiveness. First, we're going to explore the distinctions between conflict and dispute and their resolution through negotiation. Then we'll examine arbitration and its legal framework, and next the mediation principles, benefits, and compare them with arbitration, which will also be discussed. And finally, we will review the steps involved in the mediation process and its confidentiality. This next section is on understanding conflict, dispute, and negotiation in ADR. The term ADR is short form, a synonym for alternative dispute resolution. ADR provides paths in which parties can resolve their disputes without having to file a lawsuit and go through litigation, or if they're already in litigation, a way to end it early. So let's first talk about what do we mean by conflict and dispute. A conflict exists when there are two different points of view. There's conflict every day between people. Often the conflict isn't really an issue at all, just a reflection that people have different points of view about something. However, if there is a conflict that exists and one party makes a claim on the other and says, "You breached this contract, I want you to pay me damages," or "You've discriminated against me in employment and I want you to give me this job," or something like that. These are examples of conflict arising to the level of being a dispute. And the negotiation is a process used to persuade the other person, pay the damages or, do something, provide the job, something like that. So it's certainly common in business that whether it's a contractual dispute or some other type of litigation, negotiation is very common. And we learn to negotiate at a very early age when we were children. Like you see this with kids and a parent and their parents. For example, a parent might say to the child when they're at the grocery store, "If you sit nicely in the cart throughout the grocery shopping here, when we get to the checkout, you can have candy or you can have a balloon." Negotiation is something that we do on a day-to-day basis. And so I love a quote I heard somewhere. It says, "If negotiation is half talking and half listening, the more important half is listening." And so you really have to listen to the other side in any dispute, especially when you're negotiating, and you need to listen to what they're saying. Listen to what they're not saying. And watching their body language is also a help in negotiation practices. These principles of paying attention to the other person help you better perceive what's motivating them. What are they looking for? And how can you use that information to help get this matter resolved in a positive fashion? Most cases settle. Statistically, they say about 95% of lawsuits get settled. So every 100 lawsuits that are filed, 95 will settle, and the other 5% will end up actually going to trial. So why did they settle? Bottom line is it saves a lot of time, money, and uncertainty from both the plaintiff and the defendant's perspective when the lawsuits are settled. It gets the matter done and resolved so the parties can move on, and really nobody enjoys litigation. I suppose maybe a small percentage of people that do, but for the most part, people don't enjoy it. It's not fun. It costs a lot of money. There's a lot of risk involved to it. And there's also the emotional transaction. That's a type of cost to litigation that the parties experience. And the high settlement rates of litigation, coupled with positive reasons for settlement, these are some of the reasons why people will settle their disputes versus going all the way through litigation or going through to trial. But it's pretty instinctive in most people to compromise to avoid disputes or arguments. And certainly from a business perspective, there is concern about bad publicity for the business, lost employee work time when your employees are being deposed. If you're in the leadership role, maybe having your deposition taken. If and if the other party is busy requesting documents and other things from the attorney, employees are losing work time. They wouldn't be doing that other work of gathering information and going to depositions instead of doing their normal job. So there's one of the biggest risks is what about a large verdict or losing entirely? Okay, so some common business disputes on any given day we can find in the newspaper to be dealing with things like contract disputes, employment disputes, strikes, and defamation, and that sort of thing. So one of the ways that's really great is something called arbitration and the arbitration process. It works similar to a trial, but it's different in that it's not a judge and jury like we've talked about in litigation, but as an arbitrator or a panel of arbitrators instead, and there are usually 3 of them. And they're chosen by the parties involved. The arbitrators actually listen to all the evidence and make decision. In business dispute, arbitrators may be selected based on their area of expertise. For example, a dispute about a type of software and whether it infringes on copyright could benefit from hired arbitrators that understand and have worked in the area of software. You have one faculty who works for us who is a securities arbitrator. That is a complicated topic, and the decision of this expert could be totally different from that of a judge and a jury that has no expertise in the area of securities. And it adds cost because trial becomes more difficult because the legal team is not only convincing the judge or jury of facts relevant to the claim, but they're also having to educate them with expert witnesses. And this is a costly education. Next, we'll go into the arbitration process, types, and the legal framework. Where you see arbitration commonly used, again, is in contract disputes, and if there's a dispute on a contract, normally there's an arbitration provision. Union management, bargaining agreements, and stockbroker-client agreements also have arbitration provision, and also with public carriers and shippers of goods. Again, in the business world, arbitration is very common. And there's also a federal law called the Federal Arbitration Act, and that law really supports arbitration. The act says that if a contract involves interstate commerce, if it includes a written arbitration clause, courts must generally treat that clause as valid and enforceable, just like any other contract term. And there are several state statutes that are similar. And these essentially say if there's an arbitration clause in there, it's generally going to be an enforceable clause. So if you agree in a contract to mandatory arbitration, you're going to arbitration. And there's usually no way to wiggle out of that. Now, another process, or a second process we'll cover in a few slides, which is also common, is called mediation. And it's a little different from our arbitration. And the big difference here is that you have a mediator who helps the parties reach an agreement. And they set up negotiation, but they don't make a decision like an arbitration panel does. And that's an important thing to keep in mind. A mediator helps the parties resolve the dispute, but doesn't tell them what to do, like an arbitrator will do. Again, though, like with arbitration, the parties choose a mediator. All right, the process of arbitration. First of all, an arbitration is a private dispute resolution process. It can be mandatory or it may be voluntary. And what that means is a mandatory arbitration is one that the parties have no choice in submitting to. They have to have an arbitration for their case or their legal dispute. It's in their contract, or there's a statute providing its necessity. This is very common in business with contract disputes, and Again, most have an arbitration clause that requires them to submit their dispute to arbitration, or like I said, a statute. Another two terms that you need to know are binding arbitration versus non-binding arbitration. And these terms mean exactly what you think they would mean. A binding arbitration means whatever the arbitrator or the arbitration panel decides when they decide the case is binding, and the parties are bound to it. So if the panel finds in favor of the defendant and says they don't have to pay any damages to the plaintiff, then the parties have to be bound by that. A non-binding arbitration is probably a little more common, but here the parties can take it or leave it. Essentially, they can say, well, I will abide by the arbitration panel decision, or they can say they're not. And if they do agree to be bound by it, or they can voluntarily do it. And if they do agree to be bound by it, or it's a binding arbitration and they have to do whatever the arbitration panel says, if it pays the damages, they have to do that. If not, then the parties have the option of taking it to court if they choose to. Benefits to arbitration are getting the case settled, getting it resolved. It's much faster than a trial. You don't have to wait for the case to wind its way through the court system, which can take a year or more depending on what court you're in. And you can have an arbitration done quickly and have this case over with and settled. For an arbitration process, we'll select an arbitrator. You have to set those parameters, but the parties will agree on them. And the arbitrators, by the way, will be paid by the parties, and they usually split the costs. The arbitrators are paid for their time, and they usually have an hourly rate. And the parties will decide what exactly it's going to be and how they're going to split that cost. So an arbitration process is similar to a trial, but it's not the same thing. As some terms you need to know with the process. It's the process itself of arbitration starts when the parties agree to submit their dispute to an arbitrator, or they're bound to do it and they know they have to do it. And they will select the arbitrator or the panel of arbitrators, usually 3. These will be either retired judges or attorneys who are certified to be arbitrators. Not just anybody can be chosen as an arbitrator. You have to set those parameters, but the parties agree on them. Arbitrators, by the way, like I pointed out, are paid and the costs are split. And earlier in the course we talked about the court system. We talked about the difference between what a judge does and a jury does. And the arbitration panel essentially can do both, function as a judge and a jury. And arbitrators are going to be handling questions of law or fact or both. And this is also decided in advance and depends on the dispute and the specific needs the dispute requires to get it settled. The process itself is similar to trial. The parties make opening statements, put on evidence, make closing statements, but it doesn't have to follow the rules of court, which is another way that this can be a faster process. It's really up to the parties how they want to structure it. Whatever the arbitrator decides, it's called their decision, or it's called an award, and it's enforceable by the court. Next, we're going to go into mediation, its principles, benefits, and comparison, and compare it with to arbitration. So the second process, which is also very common, is called mediation. And this is a little different from arbitration, and the big difference here is that you have a mediator who helps parties reach an agreement. And the mediator sets up negotiations, but they don't make a decision like an arbitration panel does. And that's an important thing to keep in mind as one of the big chief differences. A mediator helps a party resolve the dispute, but doesn't tell them what to do, and like an arbitrator will do. Again, with arbitration, the parties choose a mediator. It's going to be an attorney or a retired judge. This mediator will have special qualifications and certifications. The benefits are essentially similar in that you get the case resolved more cheaply, faster, and that type of thing. Another big benefit of mediation is really the psychological benefit or the emotional benefit to the parties, which is covered later in this lecture. The courts have a great deal of support for mediation. They promote it. They provide training they provide people with trained mediators. They've integrated it into case management and protect and the courts protect the confidentiality of mediation processes. It also is, the court also helps to use it effectively in resolving disputes. So courts will refer cases to mediation, sometimes strongly encourages it to reduce backlogs and gives parties a chance to resolve the dispute more efficiently. They maintain lists of certified court-approved mediators. These could be attorneys or judges, retired judges, and trained professionals, mostly attorneys in Florida. I've noticed you don't have to be an attorney in Florida to become a mediator. But the market is difficult to penetrate because you have to do observations and stuff, and you need an attorney to back you up in all that process. It can be difficult, and they can be biased as far as what they are willing to do with a non-lawyer. I won't say more about that. Anyway, courts integrate mediation. Family law is an excellent place to tell you about that. Family law is an area where mediation is used to try to make more effective the process. They protect their confidentiality. There are good faith participation requirements that the courts enforce, and then they can also enforce the mediated settlement agreements. And they acknowledge that mediation can be a compassionate, efficient, and relationship-preserving alternative to trial. As I previously noted, arbitration results in a decision that's either binding or non-binding, but mediation is a little different from arbitration. And the big difference is that here you have a mediator who helps the parties reach an agreement. Like with arbitration, the parties choose a mediator, and it's going to be an attorney or retired judge. They'll have special qualifications and certifications. The parties essentially in mediation work out the problem themselves. They're having help from a mediator, but they're working it out. And it usually gives rise to more acceptance of whatever they work out. And generally we like to say in a good mediation that settles, both parties leave a little unhappy. The least painful for both sides is often the outcome with mediation. But you know that maybe that the defendant paid a little more than they would have liked. The plaintiff settled for a little less than they would have liked. But the bottom line is they had a say in how it was resolved versus an arbitration or court with a judge and jury where someone else is telling you what you're going to do. So I think we all know there's that, it's nicer to have the say in what you're going to do versus someone telling you what you have to do. And the benefits are essentially very similar in that you get the case resolved more cheaply, faster, and that type of thing. Next, we're going into a little more deeply into the mediation process, then the steps involved, and a skosh more on the confidentiality. So the mediation process is very informal compared to trial or arbitration. Unlike arbitration, mediations are confidential in that they take place in a private office. They're not open to the public. And everything in the mediation process is confidential, meaning whatever is said during mediation, it stays in mediation. Just like that old saying, what happens in Vegas stays in Vegas. Here's the same thing with mediation. It stays in the mediation. And everyone's free to discuss their thoughts on it and whatnot, knowing that it can't be used against them later on. The way the process works is everyone starts off in one room together, in conference room usually, and the attorneys for each side will make a statement, an opening statement, where they essentially present their case and what they intend to present to should the case go to trial, and what their evidence is, what the theory of liability is. And this is again informal, and they don't usually even stand up. You know, if they're sitting at the table, sometimes use photos or exhibits and things like that. Sometimes a PowerPoint. It depends on the case. This is the opportunity of simply talking with everyone and saying, you know, here's how we view the case, here's our theory, here's the evidence we have, here's what we think we're entitled to damages from the defendant. And after the plaintiff attorney speaks, the defense attorney will talk about how they view the case, which is of course going to be a little different. If there wasn't a difference of opinion, you wouldn't have a conflict. But you know, they'll talk about how they view the case. It's a good process that the parties involved can sit and hear. You know, they're listening to how it sounds from the other side. You know, what is their side of the story? Because when you have your conflict, each side has their own opinion, and they're not necessarily in tune with looking at it from the other side's point of view and how they would look at it, or what the strong points on the other side's case are. And remember, you know, that quote about negotiation is half talking and half listening, with the most important part being the listening. And that, you know, really takes place in mediation. I was waiting for that to come out because I'm an avid meditator. Finally. There's another word that just flies off my fingers when I'm working on something like this. Mediation, meditation, and medication. They're all misspelled words, so I have to be careful every time. Anyway, just a little personal fun there. You have to listen, and you have to be as impartial as you can, non-emotional as you can, and say, what would that sound like to a jury? Do I think a jury would believe that there's a contract here and that we should go forward in court? Or what would someone on the outside of this dispute think of that? And after the opening statements, and the parties go with their attorneys, insurance adjuster, whoever, and they split up and they go into their own little offices or rooms. Mediator gets to work going back and forth between them, discussing the case, discussing legal issues, ferreting out what it is that each side is really looking for, trying to obtain from the mediation and from a settlement. And this part is also confidential in these private caucuses, they're called. You know, these are the meetings with the parties and the mediator. What is said in these private caucuses, the mediator can't go out and say to the other party unless they give them permission, you know, specific permission to do so. But the confidentiality really helps. Ultimately, they're going to start talking numbers, usually monetary settlement, but there may be other factors as well. Maybe in an employment discrimination case, the employee wants to get their job back, or maybe they want a letter of recommendation, maybe an apology. Those things happen in mediation. So there can be other non-monetary issues that are discussed as well as part of the settlement in terms of money. And again, as to confidentiality, you know, in mediation, the plaintiff might say, I'll settle my case for $100,000. The case doesn't settle, and they go into trial, and they ask for $1 million from the jury. The defendant can't get up in a trial to a jury and say, you know, it's funny, they asked for $1 million because they were willing to settle for $100,000 at mediation, and they can't do that. So everything's confidential. Ultimately, at the end of the mediation, the settlement is reached. They put it in writing. Everyone signs it. And if it's not if they don't reach an agreement, the mediator declares what is called an impasse. If the parties can't reach a settlement and each and every case doesn't get settled, you know, then certainly the parties have the option to either initiate litigation or continue on in litigation. So that finalizes a presentation I have been trying to write and do well for a long time. And so I hope when I listen back to the recording, it wasn't like the last time I tried to make this better. Anyway, I hope you found this beneficial. To conclude, alternative dispute resolution offers flexible, efficient, and effective methods that help manage and resolve conflicts. And understanding the distinctions and processes of negotiation, arbitration, and mediation equips us to select the best approach for each dispute. Thank you very much. And speaking of meditation, in 2 minutes, I have a group I'm meeting with for that purpose. Not mediation, but meditation. All right, have a beautiful day. Thank you.